5 seconds to go. Start. The right to speedy trial is a fundamental right within the broad scope of Article 21 of the Constitution. In Vijay Madan Lal Chaudhary Supra, this court, while highlighting the evil of economic offences like money laundering and its adverse impact on the society and citizens, observed that arrest infringes the fundamental right to life. This court referred to Section 19 of the PML Act for the inbuilt safeguards to be adhered to by the authorized officers to ensure fairness, objectivity, and accountability. Vijay Madanlal Chaudhary Supra also held that Section 436A of the Code can apply to offences under the PML Act as it effectuates the right to speedy trial, a facet of the right to life, except for a valid ground such as where the trial is delayed at the instance of the accused himself. In our opinion, Section 436A should not be construed as a mandate that an accused should not be granted bail under the PML Act till he had suffered incarceration for the specified period. This court in Arnab Manoranjan Goswami versus State of Maharashtra and others 2021 2 SCC 427 held that while ensuring proper enforcement of criminal law on one hand, the court must be conscious that liberty across human eras is as tenacious can be. The appellant Manish Sisodia has argued that given the number of witnesses 294 in the prosecution filed by the CBI and 162 in the prosecution filed by the DOE and the documents 31,000 pages and 25,000 pages respectively, the fact that the CBI has filed multiple charge sheets, the arguments of charge have not commenced. The trial court has allowed application of the accused for furnishing of additional documents, which order has been challenged by the prosecution under Section 482 of the Code before the High Court. It was stated at the bar on behalf of the prosecution that the said petition under Section 482 will be withdrawn. It was also stated at the bar by the prosecution that the trial would be concluded within next 6 to 8 months. Detention or jail before being pronounced guilty of an offence should not become punishment without trial. If the trial gets protracted despite assurances of the prosecution and it is clear that case will not be decided within a foreseeable time, the prayer for bail may be meritorious. While the prosecution may pertain to an economic offence, yet it may not be proper to equate these cases with those punishable with death, imprisonment for life, 10 years or more like offences under the Narcotic Drugs and Psychotropic Substances Act 1985, murder, cases of rape, dacoity, kidnapping for ransom, mass violence, etc. Neither is this a case where hundreds, thousands of depositors have been defrauded. The allegations have to be established and proven. The right to bail in cases of delay coupled with incarceration for a long period depending on the nature of the allegations should be read into Section 439 of the Code and Section 45 of the PML Act. The reason is that the constitutional mandate is the higher law and it is the basic right of the person charged of an offence and not convicted that he be ensured and given a speedy trial. When the trial is not proceeding for reasons not attributable to the accused, the court, unless there are good reasons, may well be guided to exercise the power to grant bail. This would be truer where the trial would take years. Stop.